If you are attending today, it's probably because you're looking for more information on planning for end of life in Minnesota or Wisconsin. So you probably live in Minnesota or Wisconsin, and you're probably interested in estate planning because either you've never done it before, or you might need an update, or maybe you're confused and you don't really know where to start. This is meant to be an educational program, helpful for you and to answer the question, what can I do for my own protection and the protection of my loved ones? While these concepts generally apply to all the states, the subject matter of the presentation today is going to focus on Minnesota specifically because this is our primary area of jurisdiction and Wisconsin is quite similar. This is not meant to be legal advice. This is meant to be educational. And if you feel you want to ask the question, what should I do? I'm not going to be able to answer that directly for two reasons. First, this is a public forum and it wouldn't be appropriate to answer the question publicly. And secondly, we don't have an established attorney-client relationship. So this is not meant to be a consult where I give you advice about your specific legal needs. This is an educational webinar. Okay, since we're just, well, it's 10:01. We're just a little bit into the presentation and there's 12 people on now. Let's check and make sure that your audio and video is coming in clear for everyone. So I can see who's here, but I can't tell if you can hear me and see me. So if you can hear and see me, please put yes in the chat. We'll make sure that everything's working, especially with the new software we're using today. Okay, Rick is not hearing, but he's working on it. So check your speakers and let's see. Yes, Susan, Carol, Karen, Kathy, Jean, and Deb are all hearing me. So I think it's probably on your end, Rick. Gina, loud and clear. Okay, good. I'm actually using a new speaker today, so I think it's better than the old one. So that is 1, 2, 3, 4, 5, 6, 7, 8. Connie, I think there's a couple we haven't heard from. A couple. Lynn, if you can hear, please put yes in the chat if you can hear and see me. Can you track who else didn't say yes? I think one other person did. And hopefully, Rick, let us know, Rick, if you get yours straightened out. But Rick, I think you heard me well enough to ask the question. So that's good. I'm a little confused. You did it before. Oh, okay. You did it before. Okay. All right. So, okay, now Lynn said yes. Okay, so I think we've heard from everybody or almost everybody. And so it seems to be working. The consensus is that things are coming in loud and clear. So if you have technical issues during the presentation, it's probably on your end. And if you have trouble later, it's okay to exit the room and come back in or check your internet connectivity or your speakers. And if you can't figure it out, it's okay. Because after the seminar, about 20 or 30 minutes later, we're going to automatically send you a recording. If you don't see that, you can check your junk or your spam folder. So we generally take about 40 minutes to present, and then we're going to leave time for another 15 to 20 minutes for Q&A. And this is a massive advantage for those who are attending live, keeping in mind the parameters I said before about legal advice. And remember, there are no stupid questions. So save them up for the end. Thank you all for joining us today. I'm going to give you a little roadmap of where we're going to go. First, in the next 30 minutes, you'll learn the 3 ways to plan ahead for the second half of life. And you'll learn that estate planning can be easy. And you'll learn how to attain the peace of mind and protection that you are seeking. And then will be the time I promise for Q&A. So this is for you if you are frustrated about misinformation and confusion you might have about what is the ideal estate plan, if you've maybe heard conflicting advice from financial advisors, from family members, from Facebook, anywhere. Second, this webinar is for you if you're worried about leaving a mess behind for your children. And third, if you are interested in making sure what you want to happen will happen when you pass away and if you lose capacity before you pass away. I'm excited that you're here because if you act on what you learned here today, you'll be taking steps to get ahead of 75% of Americans, because only 25% of Americans have a complete and updated estate plan, and that percentage keeps decreasing. But you are ahead of them just by being here today. And as you complete your estate plan, your loved ones will be provided for. You and your family will avoid hassles, expenses, and stress, and you will have the health care that you want. So who the heck is Margaret Bear? I was born and raised in East St. Paul, family of 8 children. I'm the owner and founder of Safe Harbor Estate Law, focusing on helping clients just like you since 2013. I was raised with blue collar values like many of my clients: honesty, hard work, do the right thing, treat everybody with care and respect. At Safe Harbor, we do planning the right way. We are honest and very thorough. We treat our clients like I would want my parents to be treated. We have 12 employees now, including 3 attorneys, soon to be 4, and we are delivering service at a high level from every team member that we have. Like many of our clients, I have experience caring for elderly parents with dementia. My siblings and I work together to care for my mom, who just turned 90. And before my dad passed away from dementia in January 2019, we supported both of them with that experience. And like some of my other clients, I've experienced an untimely, tragic death in my family and a messy estate afterward. I want to share a little bit more about that story with you so that you can understand how I can relate to my clients because of personal experiences in my own life. I'll never forget how I woke up Monday morning, March 10th, 1997, just about 25 years ago. I was alarmed to hear the phone ringing at 6 a.m. I was instantly awake and I jumped up to run down the stairs. My heart was beating and my mind was racing. I remember thinking, well, who's calling and what happened? Have you ever gotten a call like that? It was Barb, the sister of my former husband, Joe. I immediately knew something bad had happened to Joe. Barb said, Margaret, I don't know how to tell you this, but Joey died in a car accident last night. I was shocked. He was already gone at age 39. Our children were not able to say goodbye to their beloved dad. It was traumatic, scary, and life-changing moment. It knocked the wind out of me like I was punched in the gut. And ever since then, if I get a call or a knock at the door at an unusual, unexpected time, it puts me on high alert. If you've ever gotten an emergency call or knock on the door like that, I think you know what I mean. Next, I braced myself to wake up my son, who was then age 11, and my daughter, Monica, age 9. My son is Ben, to tell them that their father was gone. One of the hardest things I ever did. So much changed immediately and for the next several years, and so much of my life revolved around walking them through their grief and dealing with all of the adjustments. To make matters worse, Joe's estate was contentious and messy. He had an estate plan to his credit, but there were 2 problems with it. First, it wasn't updated for changes in his life. And second, he had it drafted by a divorce attorney who did a little estate planning, but it was not a main focus of his practice. Soon we learned there were problems with the documents. Those problems made it much worse. The family dynamics and resulted in a lot of hassle, pain, and expense. The attorney's fees were over $100,000. The litigation lasted 7 years. It went all the way to the Minnesota Supreme Court. So in addition to dealing with the grief and the loss, I walked my kids through more than 7 years of estate litigation that could have been avoided or at least very minimized. It took 2 years for my kids just to get some of their belongings from their father's house, and much of it they never received. I don't want anyone to go through what our family went through. And that's why I created what I call the smooth sailing system. The system's designed to walk you through the process of a custom and comprehensive estate plan to protect whatever is most important to you. So we don't have time to go through the whole smooth sailing system today, but we're going to get you started on understanding it and how it can help you. So why do an estate plan? Plenty of people don't do it, or they don't keep it up to date, right? Why is it important to do it? This is a photo of my parents and kids. This is who I think about when I think about my estate plan. These are the people I do not want to leave a mess for. And I do want them to keep getting together for Thanksgiving after I'm gone. Who do you want to protect with your estate plan? What does planning look like for you? That's a great question. At the end of this presentation, we're going to give you an opportunity to speak directly with our client intake specialist, Gabrielle, to discuss your current situation and get you started. How do you identify your ideal estate planning strategy? Well, estate planning is very personal and depends on specific situations. Our goal today is to educate you on some of the situations you might relate to and what documents are involved in estate planning and the pros and cons so that you can get a better understanding of what documents might be a good fit for your family to protect what matters most. Now that we have the introductory statements out of the way, let's dive into the 3 ways to plan for the second half of life. To help you understand the 3 ways, we're going to use the remote control, the slide, and the bucket. 3 things that are familiar to you. And we're going to meet a fictional couple that's based on real life of many clients, Mary and John. John is 70 and Mary's 68. They have 3 adult children. Jennifer's 44 and she's on Social Security income because she has a physical disability. Jason is 42. He's had some struggles with chemical dependency, and when that's going on, he doesn't handle finances well. And Scott is 40 years old, and he's responsible financially, no particular situation in his case. John and Mary have a $400,000 home in St. Paul. They have $250,000 in retirement, $150,000 in cash, and they own a $250,000 cabin in Wisconsin. They each have a car. They live off of Social Security, a pension, and their retirement savings. The first planning strategy we're going to discuss is the remote control, planning for incapacity. There's a couple of documents everybody over the age of 18 should have in place in case illness or tragedy strikes and they're unable to take care of their own financial, legal, or medical decisions. We use the picture of a remote control for this planning because you're giving specific individuals control over your most important decisions, and you can give them some direction on those decisions. Let's say that John and Mary may have to go through what some of my clients endured. So let's say John first contacted me because Mary had been diagnosed with early onset dementia a year earlier. They spent the last week taking Mary to a battery of tests. The tests confirmed their worst fears. The dementia had rapidly become much worse than expected. This was changing their lives radically. And John called because he feels overwhelmed, ashamed, and guilty because he didn't call our office as soon as Mary got diagnosed. Now he feared Mary may be no longer able to sign the papers. My heart went out to John. I was afraid that Mary might be past the point of signing the papers too. That would mean that we need to go to court. The client would need to spend a lot of money, and I would have to put Mary on the witness stand to testify. And I knew that would be hard for her. Thankfully, that was not necessary. I had a comfortable first conversation with John and Mary in person and determined that she could sign papers and go through the smooth sailing process. John had called just in time. So a few weeks later, they were happily signing their documents in the office. Their daughter was there with them, and I got to meet her. And best of all, this burden that had been weighing on John for a year was off his plate. So part of the smooth sailing system is for every adult to have the paperwork to plan for being incapacitated. Incapacity means you're unavailable or you're unable to make decisions for yourself. You might be in a car accident, or you may be ill and unable to express your wishes. It could be temporary, it could be permanent, and it can happen at any age. Incapacity planning is very easy and relatively inexpensive to take care of ahead of time. It is very difficult and expensive and stressful to take care of it after the fact because you'll have to go to court. And with COVID, court is more expensive and more complicated. It's taking 2 hearings right now instead of 1. So you need 3 documents to ensure that you will get the care you need and have your finances handled if you lose capacity. What are those documents? The first is a healthcare directive. This is where you appoint people to make healthcare decisions for you and give directions on your wishes. Because of a relatively new law passed in 2016, if your doctor prescribes mental health treatments for you, you can give your healthcare agent permission in writing to approve those treatments so they don't have to go to court. All of our clients so far have wanted to include that important permission in their healthcare directive. And as of today, I still have not seen this option in any of the free healthcare directive forms out there. So that's something to watch for and look at if you have a healthcare directive. You want it's called intrusive mental health language. The next document is a power of attorney. With this, you appoint people called your attorneys in fact, and give them direction and authority to make financial and legal decisions on your behalf. If you don't have this, then your loved ones have to go to court if you can't sign for yourself. So for instance, if Mary fell and broke her hip and went to the hospital and then needed to be discharged to a nursing home, if John didn't have power of attorney for her, he couldn't sign the contract. Well, if she broke her hip, she could probably sign the contract. But let's say another client we had a brain injury and was unable to sign, and we did have to go to court to get permission for somebody to sign the contract to enter the nursing home. The third document that you need in Minnesota for your incapacity planning, and really in the other states as well, is a digital asset authorization. You can give people you appoint to handle your affairs while you're alive and even after you're gone legal power to access your digital assets. In Minnesota, this was adopted in 2016 after a tragedy. Jake Olson of Orono died his freshman year at the University of Minnesota. They found him, and nearby, laying on the ground, was his phone. The cause of death was unknown, and the family wanted to get access to his phone messages, of course, and his photos and his laptop to figure out what happened, and for sentimental reasons. They were not allowed access, never, even though they paid for the phone, they paid for the laptop, and the phone was part of Jake's dad's phone plan. They didn't have the right because he was 18 and he hadn't given them signed authorization. The Olsons were so heartbroken, they pushed for the digital asset authorization in Minnesota so that your family can now avoid the heartbreak and problems that they faced. So in summary, the 3 documents for the remote control is the healthcare directive, the power of attorney, and the digital asset authorization. Everyone over 18 should have these up to date and in place, and make sure they're available to the people who will need them and they know where they are. The second way to plan for the end of life is a will package, which we liken to a slide. And I'll explain that more in a minute. Wills are a basic foundational estate planning tool, and they're helpful when you're alive. They might not control everything that you might think it will after you're gone. A will package, the slide, is going to include the last will and testament and all documents we just talked about for incapacity, the healthcare directive, power of attorney, and digital asset authorization, the remote. We use the illustration of a slide with wills because they're a quick, fairly uncontrolled method of wealth transfer. Picture John and Mary's 3 children at the bottom of the slide with their hands out, and all of John and Mary's assets are at the top of the slide, and they're going to come straight down the slide to them, and they'll each get their 1/3 all at once. And this may or may not be a good thing for these adult children. Depends on the situation. For example, the son who has struggled with chemical dependency, Jason, this might not be a good time for him to get a chunk of money. Might be better to get it in trust, where it can be provided for his benefit until he's ready to handle it. Similarly, the daughter Jennifer, if she gets a chunk of money, she will probably get kicked off to Social Security until she spends it all. So in essence, the inheritance goes to the government, not to her. So the will won't do anything special for those kind of situations. It will just be an immediate transfer. And so if for some people, that works great. For others, it doesn't make sense. So let's talk about some of the pros and cons and learn a little bit more about wills. One of the pros I talked about is you get the assets to the right people. Most of the time that will work. I'll talk more about that. Second, you can sometimes avoid probate if things are titled properly and with beneficiary designations in the right situations. That can work. Thirdly, it works pretty quickly, especially if you can avoid probate. And lastly, a will is less expensive. It's shorter, it's less sophisticated instrument, and so it takes less time to draft. So it's cheaper upfront. Some of the things to think about. Like I said, the will controls less than you probably think. It only controls assets that we say pass through the will. So any assets like your life insurance, your retirement accounts, you're probably controlling them with beneficiary designations, and they're going to pass outside the will to those beneficiaries. So for example, John and Mary might say in their will, we want everything to be divided into equal thirds for my 3 children. But if they have Jennifer joint on their checking account, or she's the only beneficiary for some reason, or somebody made a mistake on the beneficiary at the life insurance company, we see this periodically from time to time, that money is really going to go to Jennifer, the person named. We can't fix that by forcing it back through the will. So the beneficiary designations and title of assets is going to override what it says in your will. So as part of our smooth sailing system, we are going to look at how your assets are titled and coach you on the beneficiary designations to make sure it all works well together. That's really important with the will. Second thing about wills is it doesn't allow you to add some specific rules. And this is also true of the beneficiary designations that you use with them. For instance, if you want your money to benefit your children, but they can't just have the lump sum until they're 25, you can't do that in will. Or if you want it to be spent only on college or any specific rules. Similarly, you can't protect it from the government programs like Social Security. It's just basically, you have basic rules that you can say, if this person dies, then I want it to go to them, but you can't put it in a trust or anything to protect it. A third thing to think about is transfer and death deeds and the beneficiary designations. So real property, there's some special rules for that. Real property is real estate. So if you have real estate in your estate when you pass away, you will have a probate in Minnesota, except for one exception. So let's picture John and Mary again. So the second of them passes away, both parents are gone, and so the children are inheriting the house as a significant asset, $400,000. So they're going to want to sell the house and get the money out of there. So what they need to do is to have a probate, hire an attorney and open a probate. And there's notice that needs to be given. There's clearance that needs to be gotten from medical assistants. Publication needs to be made in a legal publication that meets the requirements, jumping through a bunch of hoops. And then we get the letters testamentary, it's called, and that's going to authorize the person named in the will, the personal representative, to sell the house. And they won't be able to sell it before then. So it will take a little time. And that's really important. To get around the process of having a house sold through probate, many people like to use a transfer on death deed, which we usually call a TOD. And so TODs, again, just like wills, they can work slick, and sometimes they don't work well at all. Depends on the situation. So let's say John and Mary use a transfer on death deed and transferred their house to their 3 children when they passed away. So If it works well, then the 3 kids and their spouses are going to be able to cooperate and get along in, like, how much do we fix up the house, cleaning it out, what price do we list it at, who's the realtor, which offer do we accept. Okay, they can cooperate on all of that. And then when they sell it, they and their spouses are all going to need to sign and agree on it. And then if they can all split up the money. Okay, so sometimes that can work just fine. The problems we see with TODs are if people don't get along, or, for example, if someone predeceases. Let's say Jennifer predeceased and left children. You can't, in a TOD, say, if this person dies, then go to this person. It's kind of a crude instrument. And so probably her share will end up going to her husband. If she doesn't have a husband, it could go to her kids, but not in a trust. They would just get the cash outright. So there can definitely be complications, for example, if people die out of order. So there's times it works well and times it might not work well in your situation. So another issue with real estate is if, like John and Mary, they have the cabin in Wisconsin, if you have property in another state, that's going to require a probate in the other state. So 2 probates. Even if you don't have a probate in Minnesota, you're going to have a probate in Wisconsin. And so again, same issues where you could try transfer and death deed based on that state law, and we do cover Wisconsin law, but there's pros and cons to that. So if you have property out of state, it's another reason that it's important to have a plan and a good plan. So, and one more thing on avoiding probate in Minnesota. The rule is that if you have more than $75,000 passing through your will, then you will have to have a probate. So John and Mary, with their assets, if they did a transfer and death deed on their home, if they felt like this would work for them to avoid probate and they wanted to give it a try, we'd do that. The retirement accounts, we would name the kids as beneficiary after the second spouse dies. And the $150,000 in cash, we'd have to put the kids as beneficiaries on that account. And if we didn't, or if there was some mistake, then there would be a probate because of that cash account. And of course, if they did, they'd have to do a transfer and death deed on the Wisconsin cabin as well. So I hope that's helpful with their situation. And as a summary, when you go to sell the house, if you don't have a transfer and death deed, it can really take months. The courts are slower now with COVID. Everything is taking slower. They're still catching up. And it can go quicker if there's a transfer and death deed, if that works for you. And oftentimes, if cash is not available in the estate, your family would need to put up their own money, usually put it on a credit card, and then get paid back once the house sells or once we get the paperwork. If you don't need a probate, you're probably still going to need an affidavit of collection, which is something an attorney prepares, and you can take it to the bank and get access to that bank account. So those are some of the details surrounding a will and just things for you to think through. And if you want to talk to us and meet with us, we can help you figure out in your situation what are some of the pros and cons, some of the things to think through. And I thought I should define probate because it's a frequent question. You've all heard you can't take it with you, right? So when we die, we have assets in our name. How do they get in the names of other people, practically speaking? Well, probate's the court process of distributing assets to the beneficiaries you name in your will. Or if you don't have a will, the state's got one for you, and they'll say who gets it. And it's public, and it's expensive. We'd say to plan on at least $5,000 in Minnesota, and it can be an unnecessary hassle for family members you leave behind. That is the number one thing we hear from families after a loved one died, that they wish that they had not been left this mess. So it isn't horrible, but people really prefer to avoid probate. So the third way to plan is a trust package. And we're talking about a living trust, also called revocable trust. This includes all of the items in the will package, plus a revocable living trust with accompanying trust documents. So you can picture the bucket with the remote control in it and the slide. It's a special kind of a will that goes with a revocable trust, but it's still necessary. For the trust, we use the bucket because it carries your assets while you're alive, and after you pass away. It survives you. Typically, a married couple that owns assets together are going to have one joint trust. And people who have separate assets or who are together but not married will have separate trusts. Trusts are especially good for blended families if there's any concern about that. We like to think of the trust like a bucket that holds all your assets. And some of the pros are there's more control and structure with a trust than with a will package. You can have lots of conditional logic and rules, like if this happens, then that. Johnny can't have the money until he's 25. Anybody who isn't handling money well or maybe going through a bankruptcy or divorce, the trustee can hold money and just spend it for their benefit and protect it for a while. Lots of if-then scenarios are provided for. Second, like I mentioned, the trust is still alive, carrying out your wishes after you pass away. So because the trust doesn't die, there isn't a probate, as long as you get your assets in the trust properly, which is part of the smooth sailing system. It's really important to do that. It can minimize a taxable estate. So in Minnesota, if your estate is $3 million or over, you're going to pay estate taxes. And if you're married, a revocable living trust can double that to $6 million. And that's a great benefit for anybody in that category. Trusts provide protection from creditors, divorce, and bad financial decisions that a will doesn't, because the will's just the slide. You can protect a child with special needs from being kicked off of benefits. And the trustee has immediate authority to sell property, distribute assets titled into the trust, etc. We just prepare a new certificate of trust for them. They take it to the bank. They can access the bank accounts. They can sell the house. Families really like working with trusts for that reason, that you can more quickly get the job done and access the cash and take care of things. Things to think about with the trust: it's more expensive now to draft. They're longer, they're more complex, but they make things simpler in the long run, but they're more complex up front. So they cost more. And we realize not everybody can afford that right now. And it takes a little more time to move assets. Specifically, we normally recommend that you put your checking account in trust, and you probably have automatic payments on there. And the bank's probably going to make you open a new account in the name of the trust, and then you have to move those auto payments. So that does take a little more time, and we want you to know that up front. But whether you do a will package or a trust package, we're going to be advising you about some assets you might need to change the title on, or some beneficiary designations you need to update. So there will be some important follow-up, because remember, the assets have to line up with your paperwork to make it all work together. And we really are thorough about helping you do that. So here's a little recap. Wills, the slide. They're quick and straightforward. They are the lowest investment and the least involved now. They work well if you don't have a need for control or protection of anybody. They're best for like one property, or if you're renting, if you're not owning real estate anymore. And of course, the power of attorney, healthcare directive, and digital asset authorization is included in the package. Trusts are best if you want to control or structure the way certain beneficiaries receive their inheritance. They're best if you have multiple properties, especially out of state, and the trustees can sell it right away. They protect assets if a beneficiary predeceases you. In other situations where something might go wrong or something unexpected might happen, it'll be provided for in the trust. It's more expensive now, but it has a higher potential to avoid probate. And it's more flexible and powerful if you lose capacity. I'm not going into that a lot today, but they work better than powers of attorney, especially with paying for long-term care. You can do some sophisticated planning that it enables you to save half your estate or more, rather than having it all go to the nursing home. So definitely a trust works better for that. I know we went through a lot of information, and you might be wondering, well, you might feel like this lady, how do I get started? What do I do next? So that's why we allow time for the Q&A that will start in a couple minutes. And we want you to know that we've set aside time for you to speak with you individually about your objectives, your situation, and our process, and answer your questions, so we can help you accomplish your goals. So everything you learn today is going to help you prepare for the future, but you probably figured out we've only scratched the surface. So this is Gabrielle. Can you turn on your camera, Gabrielle? She's right here. Gabrielle Schließman. She's our client intake specialist. And if you click the schedule your call button that's popped up now on your screen, you'll be able to book a 10-minute call with her to talk about your goals, discuss our processes, to determine if our firm is a good fit for you. It's not a commitment, this 10-minute call, but to see if you want to go to the next step. At the end of the call, Gabrielle will set you up with a personalized Zoom or in person, if you prefer, life and legacy session with our client relations manager, Dawn Thompson. And then Dawn will discuss with you your expectations moving forward, and Gabrielle will prepare you for the meeting. And if during the call or during the meeting with Dawn, you or we determine that we're maybe not a good fit for you, or your estate plan already is updated, maybe, we're certainly happy to discuss other options, give you a referral, help you in whatever way we can. So what's the catch? I'm imitating the owl. You might be wondering what the catch is. Well, there's no catch aside from there's limited availability, of course. So we have only 10 spots available this month for webinar attendees, and then we close our calendar after the 10 meetings are scheduled. And so if you click schedule your call now to secure your spot for that call with Gabrielle, and then once the 10 slots are taken, we close down the link until the next webinar. So we limit our availability to offer exceptional service to all our potential clients because, of course, people are contacting us other ways and we need to be available for them also. So we know this can be an overwhelming process, and our job is to help it to be less overwhelming for you. And as a thank you, when you book a call with Gabrielle, she will send you some free resources that you can do on your own that are going to help you get started in this planning process and help you get things together, both to meet with an attorney and to just help your family after you're gone, or if you're unable to handle your affairs. Again, we went through a lot of information, and I'm done now. So now is the time to get your burning question answered. I'll stay on for another 15 to 20 minutes and answer your questions. So please put your questions in the chat. And I think I forgot to tell you that at the beginning, so I'm not sure. Oh yes, there are some questions in chat. I will start with those, but just keep adding your questions, please. You're welcome, Gina, for including a child with disability on SSI. Yes, that's pretty common with our clients. We do elder law as well as estate planning, and elder law actually includes planning for people with disabilities and special needs, which is not uncommon. So Gina, I have worked in healthcare management for over 35 years. I'm familiar with healthcare directives. My issue with them at a real level, how they work in the moment, is that most people use the form from their healthcare provider. Yes. And they will even have a staff member help you write it. Probably some ethical issues with that practice. When reading these, they are heavily advantaged to the healthcare facility on purpose. They may really protect the facility or the provider more than the patient and their wishes. Amen, Gina. When people come to us and they already have a healthcare directive, I always say, please let us look at it. You know, a new healthcare directive is included in your package anyway. It's not going to cost you more. Let me look at it, and then sometimes can point out to them weaknesses I see in it. And we really like our form. Let's just say that. And it can be customized for you. I agree with you. Because of this, I cannot recommend enough to use someone else like a knowledgeable lawyer or healthcare professional with your best interest. Yep, I would say lawyer, but to help you write this. You can put in any language you want, and you likely don't want the standard language in the form. Yeah, healthcare directives are a real interesting combination between the medical profession and the legal profession. And I'm always interested in learning more about the medical side and, you know, where they're coming from and how we can have better forms. But there's definitely a legal piece to it. Gina, how do I feel about a medical power of attorney, well laid out instruction over a healthcare directive? So in Wisconsin, they still have medical power of attorneys. And so you have two documents. I think the second one's called the Healthcare Directive, if I remember right. In Minnesota, you used to have two also like that. And so you had a medical power of attorney where you name somebody, and then the Healthcare Directive, which might have had a different name at the time, Living Will, where you talked about what you wanted. So Minnesota, and I like this, combine them into one document. So you only need a Healthcare Directive. And you can also put your HIPAA language in there. That's what we do, so you don't need a HIPAA form. So it's unnecessary in Minnesota to have a medical power of attorney, but we see them in other states. How do I pick POA and digital asset authorization? Okay, so Kathy, this is a good question. And we have actually a handout we send to people. Like once you hire us for an estate plan, we give you an organizer where you do your first round of trying to name those people. And we give you ideas about who to pick. So for power of attorney, or they're actually an attorney in fact that you name in your power of attorney. This is a similar role to like your personal representative, used to be called executor in your will, or your trustee. This is somebody who's good at handling money and they're responsible and pretty organized. So they don't have to do it as a career. They don't have to be a CPA or something, but do they handle their own checkbook well? And, and so you can think about how they get along with the other kids if you're naming a kid. So we can coach you on that individually. And there are professionals that we recommend that you might want to name upfront or as backup. And they do get paid, but sometimes it's well worth it. And that's something to consider. For digital asset authorization, it just authorizes the people you name in the other documents. You don't name people in that. And then the healthcare agent, that would be if somebody has a medical background, that sometimes is ideal. A lot of times it's a person who can understand your wishes, is available to be involved, and will follow your wishes. So some people, let's say at some point you wanted the plug pulled if you weren't getting better and you were in pain, and some people can't do that. So there's kind of an emotional component to the healthcare directive. That's a different role. All of the roles, I would say, they are not honorary. You don't need to do it because the oldest kid needs to be named first or anything like that. These are jobs, and there's fiduciary duty to act in the best interest of the person. So it's important. It's not just something to do to help somebody feel good, because I know sometimes it can be hard to decide who you name. Teddy. Hi, Teddy. Roughly how much will it cost beginning to end? Okay, this is a good question for Gabrielle because it varies depending on what you do. Most people don't just do the remote control unless there's like an 18-year-old or, we do this for a lot of college students. But the will versus the trust, and whether you're single and you're married, if you have real estate, there's some deeds. And so in the process, would you say about 2 months right now from when people come in to when they sign, typical, because there's some time we give you to gather information and get it to us, so that it's partly can depend on that, but I think most people take about 2 weeks. Unless it's a crisis, we try to leave time in our calendar to help people in crisis, because that happens. So it would be good to talk to Gabrielle more about that, and talk to Dawn. So that second meeting with Dawn, the life and legacy session, is really one where she can learn more about your situation and your goals, and then explain, okay, here's the packages, here's the pros and cons in your situation for you to think about, here's the cost, here's the process. So I'm sorry, but it just takes a little more time to work through that. And it's confusing to try to cover it all when it's much more understandable if we can talk about your situation. Connie, do needs differ with only one child who co-owns bank accounts and property? Yes, needs differ with everybody. Okay, let's see. Yeah, I always have concerns about the child co-owning. We'd really have to talk that through. That is usually estate planning attorneys do not recommend that, but if it's one child, it might work. And there's just different situations where we have found that to be a good solution. So it's possible, and good question. Do I need to come into your office? I have very simple needs. Susan. Okay, I'm glad that you have simple needs, and so you don't need to come into the office except for signing. So we sign with a notary and 2 witnesses. That's the law in Minnesota. So we do at times go to people's homes because they are unable to come here for health reasons usually. And there's an extra charge because of that. But we can coordinate with you because sometimes there's people there who can be witness. Your kids can't witness if they're getting money. Nobody's getting named can witness. A healthcare facility people can't witness. So there's some restrictions, but we're familiar with them and we can help you work with that. Certainly all the meetings you can do over Zoom. It's just the signing that we would have to coordinate. There will be a little bit extra charge if that's necessary. But we're happy to work with you. We have easy access into our office. I think that's it. And I still have time. It was about 5-6 minutes of questions. Any more? Are you able to set up special trusts for the disabled, Gina? Absolutely. If you have a disabled child, there's 2 ways to do it. In our wills and trusts, we will provide the language so that, let's say all your kids are healthy now, but one gets in a car accident and now they have a brain injury and they're disabled. We don't know that's going to happen today. And I hope it never does. But what if it does? We'll have the language in there ahead of time so that when you pass away, if anybody could use this kind of supplemental needs trust, then your personal representative or trustee has the power to create it then. Okay, that's a really good thing. Otherwise, like I said, the money essentially goes to the state. There's more to it than that, Gina, but I'm not going to. A supplemental needs trust is better than a special needs trust. That's what I would explain to you, one-on-one. The other thing to do that a lot of parents like to do is create the supplemental needs trust now while you're still alive. And then you can work with, like a lot of people work with Lutheran Social Services on it and their staff to make sure it's handled right, and see if you like working with them. See if your child develops a good relationship with them. So you know if something happens to you, I know who the trustee is, the trust is already set up, they're working well together. Or if they're not, we can figure out something else while you're still alive. And most clients like to do that, so they really have peace of mind that that child with special needs is all set. So we can do what you want. You're welcome. Carol, thank you so much for coming. I'm really honored you were all here, every one of you. And please go ahead and click the link to talk to Gabrielle if you have further questions. It's always a little bit hard that I can't answer them as well as I would like in this context, but hopefully you found this helpful and this will get you started and motivated to just take the next step for you. And we're happy to educate you and empower you to make the best decision for you. That's our plan. So thank you very much, and I appreciate you joining today. You're welcome. Thank you. You're welcome, Teddy, Gina, everybody. Have a great day.
End it in the top right. The top left, I'm sorry.
Oh, and this one.
Mm-hmm.